All right. First of all, thank all of you for being here. This is great, and it really shows your commitment to your clients and to your desire to improve your trial skills. I want to thank Dan. When he talks about pestering, if you looked up pestering in the dictionary, you'd see his picture. So he pestered us, but he's committed, and his TLU staff, to make this the best conference for you, take home the most knowledge, and make it worthwhile. So thank you. I want to thank, they're not all here yet, the people that came from out of state to speak here. So Philip Miller, Randy Sorrells, Justin Kahn, Ben Cloward, Ben Gideon, Daryl Isaacs, John Romano, Dick Van Devere, Patricia Kooning, Roger Dodd, Matt Morgan, and Keith Mitnik. And let me just talk a little bit about Keith. I've been friends with Keith for a long time. Someone that I consider a mentor, a tremendous author, trial lawyer, but just a great guy, always there to willing to help and teach, and he helps me all the time. Last night during dinner we had some discussions on an argument I would give on Monday on circumstantial evidence, and gave me some analogies. It's always been helpful. I mean, to come all the way out here, he's going back today, it's quite a sacrifice, and really shows what kind of person Keith is, and thank you so much, Keith, for being here. Now, Matt, on the other hand, has been staying down in Laguna Beach for a month, so it wasn't quite as far for him to come up here. But Matt, thank you for being here. I want to talk about two things briefly. Dan talked about the phones and all that. I can't use my phone, Dan, because there's no Wi-Fi, and that's on purpose, I'm sure. But be present during this thing. There's going to be a break every hour. You're going to get a chance to socialize, but I think you're going to learn some great things here. And there's two little analogies and things I'd like to talk about that recently I've really spent a lot of time on. And what these are two characteristics that I think are the most important for trial lawyers. And the first one is, and I learned this from somebody sent me a coach talking to his team. And I kind of look as running a law firm, kind of being the coach and recruiting the best talent and making everybody work together as a team. And it kind of goes like this. When you're growing up and you're in school, let's say you're in high school and you're saying, man, this is hard, but when I'm a junior, it's going to be easier. Or when you're on the football team, when I'm on the varsity, it's going to be easier. And then you go to college, and at the beginning you're struggling, it's going to get easier. Then you go to law school, and you got in law school, that's great, but then you got to pass. And then you got to take the bar, and it keeps getting harder. And then you become a lawyer, and you try a couple cases, you think you're doing pretty good. But let me tell you something. It always gets harder. And what you need to do, and what we need to do, remember, whenever you have a meaningful pursuit, it's going to be hard. Parent, teacher, counselor, trial lawyer. And what you need to do is you need to do hard better. And when things are going to get hard, and when you're tired, and you stayed up late, you got to be up in court in the morning, are you going to just go to sleep, or are you going to spend the extra time when it's tough and when you're tired to do hard better? And that's what's going to make you successful, by doing hard better. And you should like that. You know, this isn't for everyone, being a trial lawyer. So you have to have what I think, besides do hard better, the number one thing. And I learned this from a lawyer I knew back east. And I met this woman, her name was Angela Duckworth. She's a psychology PhD professor at University of Pennsylvania. Before that, she had worked in management consulting, very bright, went to Harvard. And she got burned out, and she went to New York City to teach in the public schools. And she was teaching 7th grade math and, you know, fractions, decimals. This should be something that everybody could learn. And she was trying to understand why some people were doing better than others. They were from the same socioeconomic background. And then she continued to study that. And she went to Chicago into schools. She studied. She went to West Point. She went to large corporation. And what is it that's to determine, whatever it is, lawyer, doctor, teacher, coach, what is it that determines success? And what she found, and she studied this, published on this, I invite you to watch her TED Talk and read her book. It's G-R-I-T, grit. And she has studied grit. She has grit scales, how you assess people and their grit, how you can improve it. But grit means passion and perseverance. And it's not once a week, every day. It's every day the rest of your life. You're grinding, you're not giving up. You're going to fail. But failing is going to make you successful. And you're going to keep going, and you're going to keep doing it every day. And you know, she says, you know, life is not a sprint, it's a marathon. I like more Grover, who says, life is not a marathon, it's a sprint that never ends. And that's kind of the way it is for trial lawyers. I mean, when you're in there, you're running, it's like the 440. If anyone ever did track, you run the 440, once around the track, you're dead. It's supposed to be a sprint, you're dead. So I think, take that with you. Success is going to come to you if you have grit, improve your grit, and do harder, better. So with that, I'm going to call up Keith and Matt. And today what we're going to do this morning, you know, it's so hard to organize everything and keep it in the time. So we're going to kind of have a smorgasbord here, potpourri of various topics. And we're going to talk about them, and we're going to start at the beginning about trial preparation, framing, certain techniques during the trial. We're going to try to save some time at the end to talk to people, maybe have a specific case issue that you'd like to talk about. So think through, as we go through this, some things you might want to follow up on. And we'd like to really help you, you know, get some things out of this so that you can take home with you and be a better lawyer and do a better job for your client. So how are we doing the setup here, Matt? Where are you?
So what we'll do...
One other point, which I'm on my lawyers about all the time, they'll tell you, attention to detail. One little breakdown, you have a problem. And I told Dan, attention to detail. So how is somebody going to ask questions, Dan, standing up here looking back? So we didn't have that detail buttoned down, but we're going to do it right now. So...
Okay. Brian, I got at the podium, it just doesn't look as pretty as that.
All right.
Well, we're not here about pretty, we're here about...
We don't need a podium.
We don't need the podium. Forget it.
We
So what we're going to do is, I
figured it
think,
out.
we're going to move the chairs over there. Matt, let's move the podium
Gotcha.
over here, and we'll take care of those details for you, Dan. You know, you got to get along with the judge.
And as far as formatting, what Dan has asked me to do is keep it to an hour segment. So we'll run an hour, and then I'll break. Everybody use the restroom. We'll do another hour, another
10-minute breaks.
10 minute. So our first break will come at 10 a.m. So Brian, you were just talking about grit and doing hard better. And I think for any trial lawyer, probably one of the most difficult parts in trial preparation is going through 8,000 documents and understanding all of your records, putting your records together, and making sense of it, but really mastering your records. Based upon your experience, why is it critical to master your records?
One thing I learned as a young lawyer, and I actually gave a graduation speech where I made this one of my talking points, is you need to have a healthy skepticism as a lawyer. How many people have had clients tell him, oh, I never had any prior treatment. Oh no, I was great, man. I was working out. I knew I was going to drop all this. And so, if you don't know, you're going to get killed at
Quit
trial.
scooting back. I'm trying to scoot back so you're up and I'm here. I'm going to go off the stage.
We'll blame that on Ambrose. All right.
I'll get it fixed at the break, boss.
All right.
So mastering your records.
You can't believe your client. You have to call them on everything, and you have to have that healthy skepticism where you're going to look for it. You sure you didn't have it? And when you're looking in the records, you're going to see clues. Pretend like he was on this medication. Oh, why was he on that medication? Why did he? Oh, the other doctor gave it to him. We don't have those records. And any case could go down if you know the records, the witness statements, and all of that is so important to master the record when you go into the trial.
And then so, you know, when it comes to kind of synthesizing, putting all the records together, for your trial preparation, what systems do you have in place to make sure you've covered all your bases?
Well, we work in teams as people have different responsibilities. The medical records, or I like to have summaries of your voluminous records. I think the lawyer, I mean, if it's 8,000 pages, it might be a lot, but I think you got to read them yourself. I mean, you can't really rely on a paralegal or someone else that maybe doesn't have as much experience. I think it's important to be trained on medical literature or medical terminology and reading records. There's a whole art to that. But it's not just the medical, it's the witness statements or the documents that have been produced or the documents that your client produces. I mean, you have to know all of it.
And then what are some of the pitfalls that you've seen happen over the years where maybe something happened in that process that that you learned from?
I like Keith was answering that.
I will.
Go ahead.
Yeah.
All right. If y'all don't mind, I just can't sit and talk worth a damn. So, because I try so many cases, I mean, I don't work them up anymore. I know how hard it is to work them up. I just haven't done it in years. I get in courtrooms all the time, and there's a variety in how well people mastered the medical records. And the difference is this. And it's always buried down into some record that you thought wasn't worth reading. And it's usually a voluminous piece, like the physical therapy, who cares? The speech therapy in a med mal, who cares? But there are gems in there that can help you win, and there are bombshells in there that will make you lose. How many times have you had a treating doctor who's videoed for trial, and the defense pulls out a couple records that you didn't talk to him about, and now suddenly all those opinions are at best wishy-washy because he didn't have the whole picture? Who's that on? It's on the lawyers. You got to say, I don't give a damn how many records there are. I'm going to look at every page and every sentence. And it's brutal, but it makes such a difference. Because if you've read them and you show them to that treating doctor, then they come after it, they get nowhere, doesn't rattle them. But even better than that, then your client, if there's something, and I've seen it all, where your client gets up and looks like a liar because there's something buried somewhere in those records, and they don't know about it, and they get hit with it. And if you'd have found it and prepped them, they'd have got nothing. But it's not just preventing the negative. You can turn those games into huge win and give you emotional momentum if you've learned them, because there's nothing more powerful than having cross-examine someone and say, well, what about this? Your client's suing over a back injury, and the only thing he complained about at the emergency room was his neck. Nothing about the back. Now, you go digging around and realize there's one little entry on the 3rd page of the ER record where it says back complaint. And then you get back up and say, now they pointed this out to you, and bring up the thing they highlighted that said nothing about the back. And they made a big production out of it. Will you please turn to page 3? Boom, highlight it. What's that say? Low back. And if I hadn't gone to that page, you'd have never known. And look over at the defense lawyer. And now not only did you neutralize it, you got emotional momentum because now the jury realized I can't trust that person. So in close on that, the way I think about the review of the medical records, if you go to a restaurant and the special is some whole fish entree, and I happen to love them, but I never order them. Why? Because I got to chew real slow and swallow real careful because there's liable to be a damn bone in there, and I like swallowing it whole and not worrying about it. The medical records are like that entree that's the whole fish. You have got to go hunting for those damn sharp needle-like bones because they are in there, and you will also find the best bites too.
The defense has a tendency to cherry pick entries. I'm sure you see it all the time of records. And if you know the records, like Keith says, you can use that to flip the tide or the momentum or trustworthiness. But when they hit your client on something that they deny, that's a big problem. And if you don't know about it, you better be able to act quick, but it's usually could be fatal to your case. Just one little impeachment. You're trying to be so credible and your story so believable, any little chink in the armor is problematic. And you have to know those problems in the records and proactively, as Keith said, bring them out, address them, and make them work to your advantage. And the emergency records are golden. I always call usually the emergency room doctor, nurse, to get in all the positive things that are in the records. And it makes it look a little more official that you got the emergency room person there talking about it.
I'm going to give you guys a quick warning just as an injury attorney. These chairs, when you sit down, I can see them sliding out on you.
That's why I moved it.
Yeah.
He's got me back
Ambrose
up on the
has
edge
a
of the
big
stage.
policy. I think we're okay.
And one thing too, just kind of from a practitioner's vantage point on how to use the records, there's a software called TrialPad. I have no interest in TrialPad, but it's a great software. You can, say you have 8,000 documents, you can OCR all those documents, make them searchable, and then say you're on redirect or something, and they brought something out of context on cross, and say it's related to radiating pain. You search, radiating in TrialPad, and then you'll see all the entries that pop up radiating, and then you can say, well, you said there was no radiating pain, but look, it says radiating here. So TrialPad is a great resource, and OCRing, and because think about how hard it would be to find one page like that out of 8,000 records. That's
Hey,
a
Matt,
tool.
for us old folks, what's OCR?
You can just make a document searchable. So your paralegals or trial support teams can take all the documents and make it searchable. Okay, here's something that's coming up more and more often, and I think many of you are probably dealing with it, and it's when a judge limits your time in voir dire. Brian, what strategies do you use if you have a judge that is limiting your time?
This was a big problem in California. The code was changed to say that the court cannot unreasonably restrict your time, but they don't follow that. Some judges will tell you you have 20 minutes. So there's this one judge that I knew, and I argue with them all the time. I got him up to 30 minutes to pick the entire jury. And the way we do it here, we usually start with him as 12 jurors, strikes back and forth, could be 6, 8 peremptories, and you have 40 minutes for all those people. So you got to question the jurors first. The next group comes up. It's also in federal court. Some give voir dire, but it's very limited. The judge, you got to beg for 20 minutes. So what I was doing, I was like, how am I going to get around this? This is terrible. I got all these complex issues. So I developed a board for each case that would have the 5 or 6 questions that you would ask if that's all you have. And I started doing it on a board. And then I just Xeroxed it. Every juror had it. And let me just see if I can pull one of these up. I don't know if I'm on. Okay. You can't not really see that too good, but, and it starts with, do you believe? Do you believe too many lawsuits, jury awards too high, people too ready to sue, losses cost us all too much money? Yes, no, maybe. So juror number 1 is up, and I go through juror number 1, and I show everybody how we're going to do it. I said, okay, then number 2 is, do you have negative feelings about pain and suffering awards? Please explain. Would you find it very difficult or impossible to make a monetary award for pain, suffering, emotional stress? And this one if I only have one question, this would be my second one, but do you believe today's jury's awards are excessive, too high, about right, too low? I actually put it, it's not in there. And then, this is another great question. Do you believe most people that file personal injury lawsuits tend to exaggerate their injuries? Most people. So you have the questions. The jurors, then first you go through with juror number one quickly. Then you say, okay, now I'm going to go through and you guys can just give me your answers. You'll just say 1, yes, no, maybe, yes. 2, this. 3, boom, 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 boom. You have all their questions. Maybe you do a little follow-up on cause, but you get the 5 questions that you're testing your data, you know what you're looking for. And I have numerous examples. I think they're in the materials. I mean, it's, first I'm pushing the wrong button. Here's another way I would do it, have them check it, same things. But I love this money question because that's what you're there for. I've done it other ones. Let me see here. This was a, of course, scope issues, pain and suffering. These are the 2 best questions that I believe right now. If you only had 2 questions in voir dire, these are what you'd ask. Number one, and I've done so much focus group and used these questions, and it's so predictive of where the juror is. And the first question is, do you believe most people who file personal injury lawsuits, no, it's not on there, are victims of an unfortunate accident? Yes, no, maybe. Then, the one that is the absolute killer. Do you believe most people who file personal injury lawsuits fail to take responsibility for their own actions? Anyone that writes yes on that question is a killer juror for a plaintiff. Next, you want to be on the money, because if you have a juror that's not going to give you any money, so that's why I go for the various levels. You know, we get all these motions on amounts. You can't say amounts. You can't say multi-million, and you can't anchor, but that's for another day for voir dire. But I think this is a methodology that you can quickly, and a judge in federal court, I've done it. I'm like, look, Judge, 20 minutes. You know, we're only getting 6 jurors there. 20 minutes. They just have the paper. Boom, boom, boom. We just go right through it. And most of them will go, okay, 20 minutes, that's it. And I think it's an effective way to do it. So we're going to just head through these various topics, and there's going to be all kinds of talks on voir dire, so we're not going to get all into that right now.
Right. And so, Keith, what do you do if a judge limits your time?
After you raise hell with them.
Yeah, I had one up in Lawyer that's no longer with our firm. It was a med mal case in some way out in the middle of nowhere in Mississippi. And I always asked, how's the judge handle voir dire, and didn't tell me about him limiting it. And I had my 3 hours worth of voir dire in a med mal case. We had 100 jurors in this old courthouse. No, by the way, no security. You just walk in and out. There's nobody. This is really backwoods place. And the judge got everybody in. Thank goodness we had paddles for him to raise, which moves it quicker. And the judge finishes his and says, all right, Mr. Mitnik, you have 20 minutes. And I had no idea. So I'm walking from counsel table to the podium, figuring out what the hell I'm going to do. And this is what I did, and now I use it going forward. I want to share it with you. And I now call it prioritizing and bundling. You got to figure out what is, like Brian just did, what's the key stuff? If I got to cut, and if I know I'm walking into that kind of time limit, what is it that I got to have? If I can't ask this, my chances of losing go way up. And can I take, if there are 2 or 3 of those, and bundle them into one question to move it quicker? For example, feelings against personal injury lawsuits, feelings against pain and suffering damages. Well, there's so much overlap. You can make that one question. I don't like to, but if I'm limited, I'll lump those 2 together. That's the bundling or lumping that I call. And so in that case, in the med mal case, I just got up with, they all had the paddles. Literally, he had 100 people in this giant old room. And I said, okay, folks, I thought I had a lot more time. I don't. I got 20 minutes. And I said, so I'm going to do this a little different. I'm going to ask y'all a series of questions. And in my head, I knew these are the 5 I got. Hey, Rick, there goes a great lawyer right there. He works with us, but he could represent my family, Rick Block, if I needed a lawyer.
10 trials this year already.
In any event, so I knew what my top 5 were. And I said, I don't want you to raise your paddles yet. I'm going to go through 5 things. This is an honor system. And I'm asking you to please listen carefully. And if on any one of them you would raise your paddle, at the end I'm going to say, now raise your paddles. And it doesn't have to be all 5, it can be 1. And I said, before I start, I want to explain. And then I'm not going to do it because we don't have time. But I did my little lead-in analogy so people understand how a subtle bias can have a powerful impact completely unintentionally. So I may have done barbecue sauce, one of those things. So I did that and took up about 2 minutes to do that. And then I said, all right, here are my questions. And I went, now, how many of you have feelings against medical malpractice cases? You think they're making it hard for you to get a good doctor for your family? That's 1. Don't raise your paddle, but if you would, be poised to raise it when I get to the end of the 5. And then I went through the 4 more hot med mal questions. And then I said, all right, on any one of them, and every one of them I went in and built the cause in the question. And you felt under Mississippi law, it was that you didn't start out completely neutral. I said, because you got those feelings against, kind of like the barbecue sauce, you may not be completely neutral on any one of these subjects. And I got to the end and say, raise your paddle if that's your best honest answer on any one of them. 60 paddles went up. And we went back in chambers with the judge. And I said, he says, who do you move for cause? I said, all 60. And the defense said, Judge, that's ridiculous. He didn't ask him a single question. And the judge says, when the hell was he going to do that? I only gave him 20 minutes. And he granted every one of them. So the point of the story is prioritize it, lump it, and get down to your business. My big 3 in any PI case is feelings against whatever kind of case, med mal, car crash, product. 2nd, feelings against pain and suffering. 3rd, feelings against, we're going to be talking about millions and millions of dollars, feelings against. Those are the big ones. If I got a motorcycle, I can't leave out feelings against the motorcycle. You got bias against motorcycles. Trip and fall, you can't leave out that if someone trips and falls, they must be at least partially at fault, no matter what the rest of the evidence shows. Whatever they are, they get into the top ones, lump them all together, and honor system it, bring the paddles, save time, and get them all after you've asked them. How many of you say on that, if you're in a state that says strike against, like Florida, how many of you we'd have a strike against on any one of those? Boom. And then make sure you tell the judge, I'm going to do it in 20, but it would be completely unfair if you were to deny them because I didn't find out why and get more information. I'm happy to do it. You got to give me more time. Get the judge to commit on the front end. I didn't in Mississippi, thank God the judge did. But you do it in front, and the judge is probably going to say, of course. And then he can't screw you when the time comes. So that's what I do when time's too short.
So Brian, when you think about order of proof and on a case-by-case basis, do you have a process for how you sequence your case? Do you have any checklists that you use for order of proof? Kind of, what's your thinking on order of proof?
One of my brothers is a district attorney, and he always said, if it bleeds, it leads. Well, I don't necessarily follow that. First of all, it depends on the type of case. Which I'm always doing is I take a calendar, as weeks before the trial, and I'm writing out, the order, how, of course, it always gets changed. But writing out the order and making sure that you have your areas of proof, what you need to prove, and who the witnesses that you're going to call on each element of proof. And I write it out on a legal pad, and every day I'm going back and looking at it a couple days in advance, as you may have to change it. But certainly I like to lead with witnesses, a lot of time videotapes that you can't be hurt. And I look at it as like a game, and it's not a game, but if you're keeping score, you got to score more points than the other side. And if you're putting on, and which I believe is